Dear colleagues, dear friends, good afternoon. I'm glad to welcome you at our Modern Arbitration Live project that is supported by Russian Arbitration Center and LF Academy project. Within this project, we talk to the leading Russian and foreign practitioners, lawyers, about the most interesting practical issues in the sphere of dispute resolution. Today, I'm very happy to welcome James Menz. James until recently was Deputy Secretary General and Head of Case Management at the German Institution of Arbitration, or DIS, in Cologne and Berlin in Germany. Welcome, James. Thank you very much for coming. So today we would like to talk more about arbitration in Germany, about institutional arbitration in Germany, because in 2015 Gary Born issued his famous list of Born's finest, most popular and most successful arbitration institutions. The list consists of 19 names, and DIS is among these names, which is, I think, very good for the institution. But still, DIS is not so famous outside of Germany. We know in Russia, for example, something about arbitration in Germany, but I think that not many users are familiar with DIS as an institution, not as many as it could be. We know much about Asian venues for arbitration in Hong Kong and Singapore. We know some older European institutions, and I'm sure that it will be very interesting for our colleagues to know more about arbitration in Germany. So in order to start, please first share with us what makes DIS different from other arbitration institutions, including famous European institutions. So what are the main features of DIS?
Well, thank you very much for the invitation. Thank you to the LFA and to the Russian Arbitration Center. Andrei, I'm very happy to be here and talk to you and to talk a little bit more about the DIS, because as you say, it has a name, but it's really been perceived as quite domestic and hasn't, I think, shown its qualities as much as it should have in the past, and we are trying to change that. And it's a great opportunity to talk to your audience about what we've done recently to really bring the DIS into the modern age with our new rules. The DIS is Germany's leading arbitration institution. The roots actually go back to the 1920s, when it was a predecessor organization was formed by German businesses. We have offices in Berlin and Cologne. We have about 1,500 members, and one of the largest, if not the largest, below 40 organization worldwide. We administer approximately 200 cases currently, and there are some 160 to 170 new cases annually. We offer one of the broadest ranges of dispute resolution rules of any peer, ranging all the way from conciliation to adjudication to sports arbitration. About 35% of our cases are international, involving at least one foreign party, and that's something we want to grow both in absolute terms and in relative terms. What makes the DIS unique? Well, we'd like to think that we combine the advantages, the efficiency of a smaller institution with the know-how and the outlook of a global player, not least because of the people who are working at the DIS. We are very affordable. We have very low fees, arbitrator fees and administrative fees. We have a fast rate to get to the awards, between 12 to 15 months on average. We have high quality arbitrators. We are a neutral and independent organization. We're not attached to any chamber of commerce like many of our competitors, for example.
Okay, so that was one of my questions, because you mentioned members of the organization. So DIS is itself organizational, is an entity?
We are an association or a Verein, and so we have members, and we are governed by our statutes. We, in terms of our income, it's made up of the administrative fees that we collect, as well as of membership fees and events.
Okay. You mentioned also people, so for sure in institutional arbitration it's very important to have professional staff. So can you please tell more about people behind the scenes who are doing actually administrative work? You mentioned that you have 2 offices, as I understand, in Berlin and Köln. So how people are distributed between these offices, whether you can have proceedings in both offices or maybe some other venues also. Do these people speak English, like for example you, fluently? Maybe you have also some Russian speakers or some other representatives of other countries?
Absolutely. So I'll start with the Secretariat, which is your first point of contact when you have a new case. We have 15 employees distributed across Cologne and Berlin. 11 of them are in Cologne and 4 are in Berlin. So Berlin is growing, we're expanding that. We can administer arbitration seated anywhere in the world, like most other of our competitors. Most of them, though, are seated in Germany still. And we have really a United Nations makeup of staff. I'm kind of happy to say it's quite unique. I think we have an Italian, we have a United States national, we have a Polish colleague, we have a Russian colleague who obviously speaks Russian, was trained in Russia. We have a Finnish colleague, we have a South Korean national on our staff. So for a German-based institution, we're really quite international. Then when it comes to the governance, the DIS has an executive board and an advisory board, and there you really have the who's who of German arbitration. You have most of the leading law firm partners on there. You have university professors, you have the German Chamber of Commerce, companies like Siemens, you have you also have the Ministry of Justice. So you really have the stakeholders in German arbitration represented on our boards. And finally, we have a new body now as part of our rule change. It's called the Arbitration Council, and that's what you kind of are familiar with from other competitors, having a body that overlooks the case administration. And that council consists of 15 of the leading arbitration practitioners worldwide. We have 9 Germans and 6 non-Germans, and one of them is a Russian. We have Professor Anton Asoskov, who is on the council, and we very much look forward to developing our relationship with this body.
Oh, that's great. I think it's very interesting for Russian users, because it's good that you have a very reputable professor from Russia in this council, that you have a Russian qualified and trained staff member. What about appointments? Because recently, within our interview, we talked to a member of the board of Russian Arbitration Center, where we have appointments being made by the board, Andrey Gorlenko, and we talked to her about the appointing and choosing of arbitrators. So it's how it is done, about how the parties shall choose arbitrator and all these issues. So what about appointments in DIS? Who deals with this issue?
Yeah, well, I should have mentioned that. Thank you for raising it. It's a separate body that is entirely separate from the board, entirely separate from the Secretariat and from the Arbitration Council. There are also very strict integrity rules that we can talk about later. This committee has 3 main members and 3 alternate members that step in when the main members are conflicted or unavailable. The 3 main members are Böckstiegel, Professor Böckstiegel, who I think I don't need to introduce, Vera van Houte, who is in Belgium or Belgian national, and she's quite well known from her work at the ICC. She's now an independent arbitrator, and Nadia Daverse, who is with Clyde & Co. now in Paris, also has extensive institutional experience. So it's interesting about that is that you actually only have 1 German right now on the committee. Nadia, I think, has the nationality but is not based there. And so I think that also reflects our growing international outlook. In terms of the appointment process, that's something we can talk about. The DIS allows the parties complete freedom. We don't have a closed list, for example. We generally don't have to make substitute appointments. That's tends to be the case in 20 to 30% of cases. Last year we actually had to do quite a few, but the year before not as many. So it tends to work out that the parties themselves or the co-arbitrators appoint.
So the substitute appointments, you mean appointments that are made instead of the party? If the party doesn't choose, appoint the arbitrator.
Exactly, yes, Andrei. And I mean, that's the 2 situations that you'll be familiar with, which is when the respondent does not appoint, or the parties can't agree on a sole or a chairperson. Yeah.
So for this, you have this new body, this appointing committee that deals with it, yes?
That's right. That's not a new. That's been there before, but that's right. That's the appointing committee that deals with that. The Secretariat makes proposals in those situations.
Proposals made from the Secretariat. That's very much familiar for us, as for the Russian also institution. So recently you have revised, I think, the main document for each arbitration institution, and we know that most of institutions, leading institutions, revise their rules, and new editions of the rules were issued by many institutions in the recent years. So I also congratulate you with this huge work, because I know that it's very difficult, although very interesting work. So why did you decide actually to revise the rules? So did you look into other institutions, or you saw some request from the market, from the users?
So the prior rules dated from 1998, and I think we were one of the last, if not the last, of the leading institutions.
Almost 20 years, yeah.
Which probably is a credit to the quality of the previous rules, but it was time. The market has changed significantly, the practice has changed, and our institution has evolved significantly, and so it was simply time to do it. Incidentally, it coincided with the 20th anniversary of the coming into force of the German arbitration law, which is based on Junzitrol. But those were the motivating factors. Did we look to others? Well, we wanted to stay unique, not simply copy and paste or do some follow the leader approach. And I feel like we've achieved that to a great degree. We've kept a unique flavor. But yes, of course, and as a matter of quality as well, we had to see what the others had done. And I think that exercise was actually quite interesting, and we can talk about that, because when you look at across the board, there's a certain convergence among the leading arbitral institutions, which you would kind of expect, because there are only so many ways you can do this thing and do it well. But there are also remaining differences, such as sort of those philosophical differences about party autonomy versus institutional powers, and also, let's say, fads or trends that you may or may not follow, such as this summary judgment discussion that we've witnessed, as well as things like counsel ethics, which some people brought up. Finally, even when you choose sort of from the existing menu, or you even choose the same approach, there's really different ways of phrasing things, and that can, as a lawyer, it's a fascinating process.
Yeah, especially if you draft the text in your native language. For example, when we were working on the rules, I found out that if we simply translate some of the provisions into Russian, Russian lawyer won't understand it. So it's also an interesting exercise to do the rules considering some cultural and maybe also linguistic peculiarities of the country. On the one hand, on the other hand, you should do it international, because you want users from all other countries to feel comfortable with these rules. I also want arbitrators to feel comfortable, because we can have different rules, but usually we have the same arbitrators that connect under different lists, and I think it's also important for them to feel comfortable. So it's always a question whether to do your rules unique, or maybe in some, or in the main part, to make them similar in order for the parties and for arbitrators to feel comfortable. So my next question is actually how you structured this work, because I think it's not the work only of the secretariat of the institution, but maybe you involved the arbitrators who will be using these rules and received some feedback from the users and from the arbitrators on the drafts, or maybe on some questions. Maybe you had like 2 or 3 ways how to go, how to resolve this issue in the rules, and you asked for opinion, and then it was like voting or something. So how did you work on this difficult process?
So structurally, we had a very extensive consultation. We also had a very transparent, I would say, drafting process. We basically set up 3 committees that would work together to go from idea to text, and it involved about 300 participants. Gives you an idea of how extensive the consultation was. We had a significant role dedicated to in-house counsel. It was important for us that the users, especially in Germany, but they're big companies, so they operate everywhere, would participate. We had academics, obviously. We had Germans and non-Germans, and that element was strengthened by, let's say, by an English drafting group, and that ties back to what you said earlier, because we are one of the few, if not the only, institutions that actually have two equally authoritative language versions, German and English. And as you can imagine from your experience, it was a tremendous effort to make these two texts mean the same thing, even though they're in two different languages. In terms of the details, how do we get from A to C, it was really very iterative. But clearly the main work was done by the drafting committees, which were also the smallest in terms of members, still quite extensive. But there was a considerable back and forth going from the ideas from the expert committee to a sort of a culling, which was this intermediate committee, and moving on to the drafting committee. And then it would go back and circle back to the larger group for final input and commentary.
So how long did it take?
About a year and a half. And I think that's relatively fast given how broad we set it up.
Considering that you had these 3 committees,
exactly,
a lot of practitioners, 2 languages. So
and tons of meetings where there was feedback generated. So I think it was really quite fast.
Rather effective. Congratulations. So I think it's good. So can you please tell about 3-4 main new features of the new DIS rules? So what are you proud of?
I mentioned the first thing first, although it's not a substantive thing, but it's something that's very important for us. It's a significant change in the administrative powers, where many topics are now moving to this arbitration council that used to be with the tribunal. So some people have said, well, we're becoming a true institutional rules, whereas before we were more ad hoc plus. And the idea behind that being that certain things, such as challenges of arbitrators, such as fixing the arbitrator fees where the case ends before an award, or also deciding disputes over the amount in dispute, which has a direct impact on the arbitrator compensation, used to be relegated to the tribunal, is now been moved to the DIS, i.e. the Arbitration Council. We're also administering the monies, the actual advance. So those are significant administrative changes that enhance the integrity of the case, the proceeding, and really make our landmark shift for our institution. But we think it was high time to do that. It was just not timely anymore to have the older system. Very much a sign, I think, of its age.
What do you think, excuse me, will it do proceedings more effective or more bureaucratic? So I think it's a challenge, yes?
We've heard this,
On the one hand, if you administer these issues, maybe it will be more effective. But on the other hand, it can be more bureaucratic. So how we will fight this challenge?
We've heard that concern. It's valid. We're proud that we have a reputation for being hands-off, easy, non-bureaucratic, and quick. You can really call us any time of day or night. And we've tried to set it up in a way that we can keep that. We can stay lean. For example, the council is divided into case committees, and only those committees decide on certain issues. There are 3 counselors per committee, so that already reduces the head count. Everything's done electronically or by phone. No physical meetings. So we've set ourselves internally very ambitious deadlines to respond to to make any decisions. And I think there's also something in the DNA of the DIS that we don't want to become the ICC. We don't want to be overbearing. And for example, we're still not getting a full copy of the file. That's something that automatically, to some extent, contributes to bureaucratization. So it is going to be a challenge. I think it's one of the challenges going forward, but I'm optimistic that we'll...
Wish you success, and I'm sure that you will fight the challenge. So what other amendments that could be interesting for the users?
Yeah.
Maybe smaller or just some...
Sure. So I would say the 3 main areas are efficiency and speed, multi-party, multi-contract, and then what I would call unique continental law elements. So efficiency and speed, we've reduced the periods for appointing arbitrators at the beginning for constituting the tribunal. We've introduced a deadline for the award, 3 months, which is sanctioned or penalized with a fee reduction by the DIS if the arbitrator succeeded without a good reason. We've
Have you applied it already?
not yet,
Not
because
yet.
the first cases started in March. We haven't had an award yet. We will be quite strict, though, about that. You don't want to be the first arbitrator to test our resolve, let's put it that way. And in terms of efficiency, efficiency is really one of the guiding themes. You see it in the provisions that allow the DIS to reduce or adjust the fees, taking into account the efficiency of the arbitrators, which can be an encouragement as well. Arbitrators can make a great contribution to handling a case, and they should be rewarded for that. You also see it in the provisions that allow the tribunal to take the party's conduct into account when setting and allocating costs. It's the guiding theme for our case management approach, which I can talk about a little bit later. And in terms of the multi-party, multi-contract there, we've introduced some very modern provisions. I would say they are conservative in the sense that we leave it up to party consent. It's not the institution that decides on whether the parties have consented to bring together certain arbitrations, for example. What I call the continental element, that's something that's interesting. I think that makes the DIS unique. It means provisions in various places that promote settlement and promote alternative dispute resolution. We really think that the future belongs to arbitrators and institutions that can intelligently deal with disputes. And that means that not every dispute belongs necessarily in arbitration. We have a provision that permits the appointment of a third party neutral to advise the parties on the right mechanism, not on the right outcome, but on the right mechanism.
Something like mediation?
No, that's actually someone who's like a traffic cop who says, well, this case could go into or should go into mediation, this case should go into adjudication. The parties can obviously decline the appointment. They don't have to participate. We have other provisions that encourage the tribunal to facilitate settlement. We have provisions that allow the tribunal to use a technique that we are in the German-speaking world quite proud of, which is called the provisional assessment. So it's something that gives initial guidance to the parties about where the case is going, what are the strengths and weaknesses. And we have provisions that permit you to turn a mediation into an arbitration award if you need an enforceable title. So there are different elements that really reflect this spirit, I would say.
That's very interesting. And just finishing and returning maybe to the issue of DIS and mediation. So do you have your own mediation rules, or if the parties want, you refer to some other institution or some mediators, how it's usually done?
We have our own, and we see mediations followed by arbitrations, although ideally, it stops. But yes, we have our own. They're very good. They've thought about all the key issues that you need to think about. We really recommend them over ad hoc. But we're open to non-dis mediations. And what I talked about earlier, this sort of turning a mediation into an award, you can do this mediation under any set of rules. Obviously, you're not bound to it, but we have a financial incentive to use the DIS mediation rules. So I think this what I said earlier, this combining these different approaches. You see a lot of demand from the companies, and that's where it really comes from. They want to see people who are skilled in these different mechanisms, and we're trying to respond to that.
Yeah, I also agree, and I also suppose that the future of other ADR mechanisms, such as mediation, in Russia also is rather good, and we see that the questions from the users arise about mediation turning into arbitration, because one of the problems of mediation is that you cannot enforce the agreement after the mediation. So we also try to suggest them these med-arb proceedings. So the question that is discussed as I know among lawyers all over the world about this changing hats from mediator to arbitrator. So if you encourage arbitrators to settle the dispute, so won't there be problems with this arbitrator acting not more as arbitrator but already as a mediator? So do you see any challenges here and some maybe threats?
Yeah, definitely, but I think we can handle them. So there's three things I want to say. One is the arbitrators, the parties can always object and decline these types of mechanisms. So if they want their traditional arbitration, if they want their common law type of arbitration, they can definitely have it under the DIS rules. The second thing I want to say is that I think the DIS rules don't envisage a changing hat situation where we have ARB med ARB. I personally, and I think the rules, if you look at them, don't really consider the arbitrators to be suitable mediators in those circumstances. And the third thing is, if you look at the tradition that is reflected in our rules, the arbitrators don't act as or mediators themselves, typically at least. They would tend to have, what I mentioned earlier, this assessment, they would tend to have a role of pointing out the strengths and weaknesses of each party's argument, asking or pointing out where there's need for additional arguments or evidence. And certainly from that assessment, which if done well, really helps the case. The parties can see where things are going, but it's not a prejudgment. And ideally, you have a settlement resulting from that assessment, or at least you have a streamlining of the arbitration.
Yeah, I think it can encourage parties also to settle the dispute, so when they understand where it's going. So I think it's also one of the good features of arbitration. So when you have a professional arbitrator, or you have this professional opinion, how the dispute is being evaluated, so maybe there is no sense of proceeding with the dispute, and it's better for the business, for the companies to settle the dispute. But if mediation is not successful, so we go further with the proceedings. And as far as I know, you have the new Article 27 in the rules that provides for the case management conference. For me, I suppose that it's one of the most important provisions in the rules, because we also worked on this closely, because it really helps make proceedings really effective in order for the parties and for the arbitrators to be very well prepared to the hearings. Is it really new, or it was already used without the relevant provisions by the arbitrators in DIS proceedings? And what actually was the idea behind this special article in the rules?
Yeah, and that's something we're really proud of. I think it is a unique feature of the rules. And the case management conference as a concept is not new. Many of the other arbitration institutions have introduced it. Many of the experienced practitioners at the DIS already did it. But we have a significant share of first-time or one-time users and arbitrators at the DIS. We have a significant number of low-value cases, and the less experienced stakeholders didn't used to use it as much, and we really want to steer them a little bit in that direction. We also have something for the more experienced ones, and so having that as a mandatory concept is the first change. Having in-house company representatives participate is a second element. I think it's very important for them to devote the time to ask the tough questions in advance, and then to support the result, ideally, or at least to participate in the decision-making at the conference. And the third thing, which is kind of unique, is the agenda, the fact that there's some things you have to talk about at this conference. What are the things you have to talk about? You have to talk about, do you want an expedited version of the case or not? Second, is there a way to resolve this amicably or through alternative dispute resolution? Third, are there going to be experts, and if so, how are we going to structure the expert procedure? And finally, and that's something quite unique, do we want to adopt any of the following efficiency-enhancing measures? And then you have an annex number 3, which we call Annex 3. And some of the measures are quite familiar: bifurcation, reducing submissions, limiting hearings. But we also have things in there that give you a sense of the philosophy of the rules, such as do we want to limit or exclude document production? Do we want to have this preliminary assessment mechanisms? So it gives you a sense of really tested efficiency-enhancing measures that you have to discuss and then consciously, opt for or against, with the tribunal being the ultimate arbiter and having the power to decide independently.
I think that's very, very good idea, and I hope that it will be in demand by the parties and by the arbitrators, and it will help to make proceedings more efficient. And how usually this case management conference is being conducted? So it's can it be conducted via phone or via email, or maybe, or they need to meet personally, all the parties and the arbitrators?
The rules leave it open to all the participants, and typically it would be a meeting, given the fact that most of the participants tend to be from Germany in the domestic arbitrations, but the international ones I can see telephone conferences. So this is very much, I would say, up to international best practice.
So it's flexible.
Yeah.
Okay. So you mentioned the expedited proceedings, and I know that it's also a kind of hot topic in arbitration. I know that UNCITRAL discusses where we need some kind of standards in regard to expedited proceedings. Different institutions suggest different expedited proceedings. So can you tell more about the expedited proceedings? You mentioned that parties can agree on the expedited proceedings already at the case management conference. Do you really think it's possible that the parties can at this stage agree on change of proceedings and make them expedited? For example, the respondent maybe is not very eager to have expedited proceedings in some cases. And do you have the also option to agree on expedited proceedings in advance, so before the proceedings?
So yes, we have the traditional option. So you can use our model clause and provide for expedited proceedings. And the expedited proceedings, in essence, and they're very short, are basically a 6-month case following the Constitution, 6 months from the Constitution. Historically, we've had a similar set of rules, and it has worked. We've always kept the 6 months. The idea we've introduced of having to talk about it at the case management conference, do we want the expedited or do we want the normal, was an answer really to this trend of having a value-based automatism, right? What the ICC has done, $2 million, Switzerland, 1 million francs. We thought about that, we talked about it, we decided against it. The users, the companies, were actually quite opposed to it. Now, some of the reasons were you don't know what the case will look like. Some of the $1 million cases are very complicated, very important. You don't know whether people will be available. There's game playing going on with the claim structuring. And finally, are you going to take away the number of arbitrators from the parties? That's was a very big concern that the ICC has, I think, in my opinion, not perfectly resolved. And so all of these things contributed to not adopting the solution. And finally, we actually weren't sure where to set the value, to be honest. I mean, that was a minor consideration, but the fact is that for us, a €1 million arbitration, looking at the structure of our caseload, is actually not a small case. So those were some of the considerations. We hope it'll work out. I think we're optimistic that there is a sense to it, because at the time of the CMC, you know the case. You understand what the facts are, what the case is about, roughly at least. You know if your lawyers are available, if your witnesses are there, and so you can make this decision in an informed way. If a party wants to obstruct, that may be a problem, but we think that in those kinds of situations where expedition is an option, the advantages will be obvious to everyone.
Yeah, you can save costs. So, and the respondent shall also understand that if he loses, he can bear costs of the other party, and so
exactly.
In this case, the burden will be higher. So, I think it's sometimes it can be more favorable for the respondent not to risk the standard proceedings, and to choose these cost-saving proceedings. So, I think it also makes sense. So, your main goal, I think, in drafting the rules was to make it as flexible as possible. Yes? So I think to leave this DIS classic approach of so ad hoc plus or something with some new features, but still to provide parties with the flexibility.
Yes, flexibility, but also really to, let's say, emphasize what makes us unique and special. So there's some of the elements I mentioned before. I would say we're definitely no longer ad hoc plus. We have sort of this institutional clothing that we maybe didn't have before, and so that I would say it definitely elevates us into the realm of a full institutional arbitration institution. But I do want to emphasize that we've I think kept at least the philosophy that we had under the old rules, and we've emphasized some of these unique elements, which I hope allows us to travel outside of the country as well.
So that's very interesting how the rules, actually as the main document, but being still the document, can change the perception and the style of the institution. Yes, so it's interesting how it goes from the document to the company to the organization. Yes, so it's interesting. What changes maybe you personally would like to see in these rules, but for some reasons it was maybe too revolutionary or too brave to introduce it now, but maybe you would like to see in these rules?
Sure. I mean, there are two things. One is probably happening, but not this year, is the emergency arbitrator. We didn't include it. We thought about it. The main reason we didn't include it is that the German national arbitration law is being changed as we speak, and there may well be a provisions or more on emergency arbitration. We wanted to ensure that our rules were consistent with those provisions. So most likely, you will see those provisions in the DIS rules sometime in the future. We actually already have a type of emergency arbitrator in our sports arbitrations, which is working quite well. The second thing that I personally felt strongly about was publication of redacted awards. Our rules, our confidentiality rules, were strict, and they've become even stricter, which is attractive to many companies. But for arbitration overall, and I think for us as an institution, it would have been advantageous to have that flexibility. We brought it up. There was a strong discussion about it. I think the companies really resisted this. We wanted to move from a default non-publication to the ability to publish unless someone objects, and some other. I think VIAC has that, and others have it. So it doesn't mean that there's suddenly this flood of publications, but at least it gives you the option when you have the resources, when you have the interesting cases, to do that. We've tried doing it the old-fashioned way, which is collecting consent from different companies for M&A awards. And the result has been very disappointing. We've had only 6 or 7 consents. And there are some very interesting nuggets of information in terms of material law, but maybe more importantly, Andrey, it's showing to the world and to the skeptics that arbitrators are doing a very, very good job. They're distinguished jurists. They're writing these awards with great care, in many ways much, much better than court judgments, and having really delved into the issues. And so I think it gives a sort of bona fide to the process that you just don't have without publishing these kinds of documents.
I fully agree with you, and I see the demand here from the lawyers for these awards, redacted awards, is huge, and that's why actually we launched this section at our website, because our rules provide for the possibility to publish this redacted. We have 1 or 2 now available there, but we see that the interest to this award is huge, and we understand that it's also important for development of arbitration and for the training of arbitrators, because also arbitrators can look at the award, can look at the structure of the award, how the good award shall be actually written, and so what arguments are brought by the arbitrator. And I think it's very important for development of arbitration, and I hope that in the future it will also be one of the amendments, maybe in some future versions of your rules. And now, so when you finish this huge work, actually, what are the next steps for DIS? What are other projects?
Sure. We are launching a roadshow, and we're taking these rules around the world, including to Russia. So please stay tuned. We'll obviously keep the community informed about where we're going and when we'll be here. We will really use this opportunity to showcase all the things that are in the rules, including by people who've contributed to the drafting. So we'll have very senior representatives on this show. The next challenge will be to really do a good job at implementing them. We've obviously started this, but finding the balance we talked about earlier between new powers and lean administration will be one of the challenges, but also filling some of these rules with life and interpreting them and developing a good practice. Finally, or additionally, one of our big challenges continues to be penetrating domestically and internationally, really developing the reputation of the institution. That's going to continue to occupy us, as will our project of developing contacts with companies. We're quite proud of the contacts we've developed, the conversations we've started. We feel like a direct contact and conversation with the companies and the customers effectively is essential to staying attuned to what people actually want. And then we are continuing to grow the non-commercial areas. This is something that makes us unique. Sports is doing great. Other areas, ADR especially, we see huge potential and encouraging numbers. And so really showcasing the DIS and positioning it as the leading dispute resolution provider in Europe That's sort of the midterm goal.
I wish you all the success, and I hope that you will have some Russian-related disputes. So I wish all the success.
Thank you.
Yeah, and we will have more. So I wish all the success to DIS and to you personally. Thank you very much for coming.
Thank you, Andrey.
Thank you.
Appreciate
You're
it.
always welcome.